An ailing uncle attempts to distribute his wealth. He signs a letter promising a townhouse to his nephew, hands over an uncompleted share transfer to his sister, writes a check to his favorite charity. But he dies before the paperwork is properly registered. The law does not grade on effort. If these transfers fail the mechanical requirements of property law, the assets do not reach the intended recipients. They fall directly back into the uncle's residual estate, defeating his final wishes entirely. Creating an express trust requires two mandatory pillars. First, a valid declaration of intent. Second, valid constitution. Constitution means the subject matter, the actual property, must be legally transferred to the trustees. A valid declaration of trust carries zero legal weight if the assets themselves are not properly moved. Subjective intent is meaningless without objective execution. Without the proper transfer of title, the trust is void, and the assets remain the property of the transferor. In the 1862 case of Milroy v. Lord, Lord Justice Turner laid down a rigid standard. To constitute a trust, a settlor must do everything necessary to transfer the property according to the specific nature of that property. This establishes a foundational maxim of property law: equity will not perfect an imperfect gift. Different assets demand different mechanics. Under Section 52(1) of the Law of Property Act 1925, transferring the legal title of land requires the execution of a formal deed, which must then be fully processed at the land registry. Transferring private company shares requires a separate process. The transferor must complete a stock transfer form and submit it to the company. Legal title does not pass until the new owner is officially written into the company's register of members. Under this strict common law analysis, our hypothetical uncle has failed on all fronts. To save these transfers, we have to examine the precise boundaries where equity is willing to launch a rescue operation. Let's analyze the uncle's failed share transfer using the 1952 case of Ree Rose. The core issue: who possesses equitable title before actual company registration? The court established the every effort test. If a transferor completes every required personal action, equity deems the transfer complete. Applying this to the facts of Ree Rose, the transferor had executed the stock transfer form and handed it over with the share certificate. The only outstanding actions required to finalize the transfer belonged to a third party, the company directors. The court concluded that a trust should be implied. Equitable title successfully passed to the donee the exact moment the paperwork was handed over, bridging the gap until legal registration was finalized. This is an objective rescue. Equity steps in, but strictly on the condition that the settlor has mechanically completed every single step required of them personally without defect. When a settlor fails the objective every effort test, the analysis moves to a controversial, highly subjective frontier. In Choithram v. Pagarani, a settlor made an oral declaration transferring his wealth to a foundation. He died before he could physically transfer the share certificates to the other foundation trustees. The Privy Council found a narrow exception. Because the settlor was already one of the trustees of the foundation, legal title to the assets was technically already vested in him. The court ruled it would be unconscionable for him to resile from his own valid declaration under those specific conditions. This logic was pushed to its absolute limit in Pennington v. Wayne. Here, a donor signed a stock transfer form, but simply left it on her auditor's file. It was never delivered to the company or the intended recipient. Despite failing the ever effort test entirely, the court ruled the gift was complete. They deemed it unconscionable to recall the shares, relying on the fact that the nephew took detrimental action by agreeing to become a director based on the promise of those shares. A warning for exam analysis: never leap straight to Pennington. Always apply the strict mechanics of Ree Rose first. Pennington is a volatile doctrine of last resort. While unconscionability exists to prevent glaring injustice, it is intensely fact-specific. It blurs the boundary between an imperfect gift and the separate legal mechanism of proprietary estoppel. Returning to our uncle's estate, we must resolve the final assets, the uncashed check and the physical property. There is a distinct posthumous rescue mechanism found in the case of Strong v. Bird. This rule can perfect a flawed lifetime gift immediately upon the transferor's death. It requires 4 strict conditions. The transferor must have intended to make an immediate lifetime gift. That intention must continue unchanged until death. The transfer must have failed solely due to a lack of formalities, and crucially, the intended recipient must be appointed as the executor of the deceased estate. The logic operates as a specific exception to the rule against assisting volunteers. When a person dies, their executor automatically receives legal title to the entire estate to administer it. Equity allows this coincidental transfer of legal title to complete the transferor's unrevoked equitable intent. Move the timeline forward. Assume a trust has been validly constituted. Legal title and equitable title are now officially severed. The beneficiary now holds the equitable interest. This is a distinct vested proprietary asset. It is a piece of property in its own right, meaning the beneficiary can sell it, leverage it, or give it away. Moving this newly separated asset triggers an anti-fraud statutory trap, Section 53(1)(c) of the Law of Property Act 1925. The statute dictates that any disposition of a subsisting, meaning an already existing, equitable interest must be executed in signed writing. Attempting to transfer this interest orally is entirely void. The law requires a definitive paper trail. Trustees must know exactly who owns the beneficial interest they manage, protecting them from executing the trust for a fraudulent claimant. Section 53(1)(c) is fiercely litigated in tax law. When wealthy individuals move equitable interests in writing, the state assesses stamp duty on the transaction. In Gray v. IRC, a settlor named Hunter attempted to bypass this tax. He gave an oral direction to his trustees to hold his subsisting equitable interest for his grandchildren, intentionally avoiding a written document. The House of Lords closed the loophole. They ruled that an oral direction to trustees constitutes a disposition under the statute. Without signed writing, the transfer of Hunter's equitable interest was strictly void. Compare this with the mechanics found in Vandervelde v. IRC. Vandervelde held an absolute equitable interest under a bare trust. He instructed his trustee to transfer the legal estate to a third party, intending the equitable estate to travel with it. The court ruled Section 53(1)(c) does not apply here. When a legal transfer passes absolute ownership, the greater title carries the lesser. Do not confuse the strict writing rules of Gray, which apply when moving only the equitable title, with the collapsing bare trust in Vandervelde, which transfers absolute title. A trust requires exact mechanical constitution. Equity may intervene to rescue the diligent or prevent unconscionability, but once established, the equitable interest becomes a strictly defined asset, requiring precise statutory compliance to move.